My name is Marcus Harris. I'm a Chicago-based software and intellectual property attorney. My office develops intellectual property protection strategies for clients based in the United States and internationally. And one of the questions that comes up in our practice on a regular basis is what is involved in the federal trademark application process? And I think our clients typically misunderstand the difficulty associated with filing and obtaining a trademark registration. Sometimes they think that it's similar to obtaining a domain name, and really the two couldn't be more different. The trademark application process starts with selecting a potential trademark that has the capability of functioning as a trademark and then conducting a trademark search to determine if that mark is available and to understand whatever issues or concerns or problems may be present with the application of that trademark for registration. Once you have selected a going forward trademark to apply for, you want to develop a trademark application filing strategy. Now, depending on your needs, your budget, and the particular mark that you are seeking to register, you may have a variety of different types of trademark applications that you can file for that trademark. Now, once you have developed a trademark application filing strategy, the next step is to draft the trademark application. Now, one of the most important elements in any trademark application is the description of goods and services. And the challenge with drafting a description of goods and services is that you want to draft a description that's broad enough to allow you reasonable flexibility to grow that product, that brand, that trademark over the life cycle of that particular registration. You also want to be careful that it's not so broad that it unintentionally conflicts with pending trademark applications or registrations. You also need to be mindful of potential rejections by the trademark office to that description of goods and services. Once you have filed your trademark application, it typically takes about 4 months for the trademark office to provide any substantive feedback on the trademark application. And one of two things is going to happen. One, the trademark application will simply move on to the next phase of the trademark application process. More common, though, is that you will receive what's called an office action from the trademark office. And an office action is a rejection of the trademark application, and there are a variety of statutory bases upon which the trademark office issues rejections of trademark applications. Once it is issued, you will have 6 months within which to file a reply to that rejection, and assuming that you successfully overcome whatever rejection that the trademark office has issued, the trademark application will then move on to the next phase of the application process, which is publication. Now, the trademark office publishes applications for 30 days to allow interested third parties that believe they will be damaged by the registration of your mark to file an opposition to your application, or to file a request for time to file an opposition to your trademark application. Now, assuming that no opposition is filed or that you are able to successfully overcome any opposition to the application, the trademark application will issue in the case of a use-based application. If you have filed a intent-to-use based application, instead of issuing a registration certificate, the trademark office will issue what's called a notice of allowance. And once that is issued, you will have 6 months to prove to the trademark office that you are actually using that trademark in interstate commerce. And if you can't do it within 6 months, there are certain extensions that are available for a fee. Now, should you have any questions about any of the issues in this video or any of our other videos, please feel free to give our office a call at 312-263-0570. Thank you.